Ohio trial, and what are your initial thoughts?
Interesting case, and I'm surprised that the jury is deliberating for as long as it has. Obviously, we know it's a death penalty case and it's a capital case, and the defense has done a good job of pointing the finger at others, particularly Boggs, and attacking the victim, probably too strong of a word, but pointing out that there may have been folks dealing with drugs or prostitution and that type of thing. Obviously, death penalty panels tend to be a little bit more conservative, but we thought this was a pretty strong case from the prosecution's perspective. So as hours turns into days and days turn into weeks potentially, we may be looking at a hung jury here. So don't want to get ahead of ourselves, but I thought this was a particularly strong case from an evidentiary perspective. We had a lot of evidence, such as the alarm.com testimony and the video surveillance for the neighbors showing Ford's alarm being turned off and then someone leaving his residence and returning to his residence before and after the arsons were committed in the middle of the night at around 3 or 3:30 a.m.
That's right, Neama. So this trial, you're right, it might be a hung jury. Too soon to tell, because one of the things I want to talk about is the fact, as you pointed out, multiple charges, a death penalty case. We have 29 charges in this case. So in and of itself, for a jury to go through and look at every single charge and fill out the jury form the way that they're required to, I think in and of itself, that could take a good amount of time. And that's without taking into account having to talk through the evidence for them to determine the facts as they believe them.
Ashley, you're right. And you never know what 12 jurors are going to do when they go back into that deliberation room. Some are ready to vote right away, and others want to consider all of the accounts, go through the jury instructions, consider all the evidence, particularly in a murder case. So some jurors just like to be a little bit more deliberate and comb through each piece of evidence, hear testimony, handle different pieces of evidence. Again, I thought it was a strong case. It's too early to tell, but again, time tends to be the friend of the defense, in favor of the defense. So if you're the prosecution, if this drags on for days, you might start to be concerned about one or two holdout jurors.
And a reminder to everyone that, as we know, the jury is sequestered. And by that, I mean they cannot have any access to any electronic devices while they are spending the night at the hotel. There have been some other rules put in place. And so it is one where they are hard at work. And I think that the judge has taken steps to ensure that there are no distractions, that there's no inadvertent, inappropriate seeing anything on the news. And so when they are deliberating, Neama, in a case like this, they are really deliberating. They have lunch brought in, they're there working, they can go late. And so it's not as if they're going to have a lot of natural breaks because they're not sequestered and they go out to lunch and come back in and then they end their day maybe to get through traffic or do some of those other logistics. It is a lot. I mean, they are pretty much locked down, would be my description, when you are sequestered as a jury.
And there's two schools of thought when it comes to jurors sequestration. From the defense perspective, when you have a high-profile case like this, there's going to be a lot of public pressure for these jurors to return a guilty verdict. I mean, that's one of the reasons we saw in Derek Chauvin that the defense kept asking for sequestration. The judge ultimately, that's not something that was granted, but defense attorneys like sequestration in these types of high-profile cases because it does remove some of that pressure. When folks are, coming and going and they see the media outside the courthouse, they might be thinking to themselves, even if not explicitly, implicitly, what's going to happen if I hang this jury, if I return a not guilty verdict? From the prosecution perspective, I didn't mind sequestration because ultimately the jurors want to go home. They want to get out of there. So any type of pressure, whether it's a Friday afternoon or not having their electronic devices like this jury doesn't have, imagine not having your cell phone for several days. I mean, that can be very challenging and put pressure on jurors to return some sort of verdict. Now, it's probably safe to assume that this is not going to be an acquittal, a not guilty verdict. So we're likely looking at either a guilty or a hung jury. So the sequestration may also benefit the prosecution in a case like this.
We're discussing previously 29 charges, and I have before me the definition of aggravated murder in the state of Ohio, and it is that the defendant did purposely and with prior calculation and design cause the death in violation of the law there. So purposely with prior calculation and design. Here's what it feels like to me, and I'd love your opinion based on all the trials you've been involved with as a former federal prosecutor. It sounds like to me that maybe the jury is hung up on, okay, maybe he started the fire, but he didn't do it with the purpose or intent of everyone dying inside the fire. But on the other hand, by starting the fire at 3 a.m., if the jury is concluding that, and that's an if, we don't know what the jury's doing right now or what they've decided, that maybe then it had to have been purposely because he had to have known there might have been people in there.
No question. And that's one of the benefits of having Joy there on the scene. There's really no substitute for having someone who's actually in the courtroom, who's watching the jurors, and one of the benefits that the court TV viewers have. It's not the same just to watch it, via the court TV videos. So let's just talk about this particular jury question and how it helps the prosecution. And this is reading the tea leaves here a little bit, but the defense was going to challenge the identity of the arsonist, right? I mean, they didn't dispute that this happened. They're just saying that it was not Stanley Ford. That was their defense entirely, and that it was someone else. So now you have the jurors, at least one, who is focused on intent, that word purposeful. And from a legal perspective, there is no requirement that Ford intended to kill people, just that he intended to start this fire and that the fire was a legal cause of the death. The example that we always give in law school is, if I point a gun at someone and I pull the trigger, that's all the intent that I need. I don't need to intend to actually kill someone, just intend to commit the actual act, which is pulling the trigger. So you obviously have at least one juror, maybe two. Sometimes they're scientists or engineers that are really deliberate. They're going through every jury instruction word by word with a fine-tooth comb, going through these elements. But again, if the prosecution is past identity here and the jurors are now focused on Stanley Ford's intent, I think they're well on their way to a guilty verdict.
It's interesting to me that the defense, even while they're putting on a defense, is still saying we don't know exactly which witnesses. We're having some difficulty getting them here. Because if you choose as a defense to actually put up a case, I feel like then you'd have those logistics worked out. What do you think?
Ashley, there's been a lot of criticism of this defense team. Some of the attorneys have a lot of experience, but have never tried a case in federal court. And this is sort of the sloppiness, for lack of a better word, that really has sort of surrounded this whole defense trial. I mean, you have to have your witnesses ready to go, especially in federal court. And Judge Donnelly has already expressed very little patience with his defense team. To waste the jurors' time and the court's time by having only 2 witnesses a day is not a good look at all for the defense here.
And I agree with you. Every court, I know when I'm in court, you have to be efficient because you have a lot of people's time in your hands. And so I can understand some of those frustrations. Neama, the fact that this car, after it was identified and law enforcement was looking for it and an officer drove by and saw it, was not hidden. It's not as if the person driving it hid it somewhere where it could never be found again. It was out in the open. What, if anything, might that suggest to you, or if you were a defense attorney in this case?
Ashley, when you're a prosecutor or a defense attorney and a case goes to trial, a case where liability is clear, you ask yourself, why are we here? And we're here in this particular case because Tennessee is prosecuting her with murder. Normally these cases are manslaughter cases. You don't have that criminal intent to actually kill someone. So the Tennessee statutes, the way they're written, actually do allow for this kind of prosecution, even though obviously it's a death case, it's an officer-involved death case, but it may to some folks be an over-aggressive prosecution. So what the defense is trying to do here is play the video, show that this is not someone who had any intent of intentionally killing a police officer. This is someone who obviously was drinking, obviously was driving, is criminally responsible, but not a murderer. This is someone that should deserve a manslaughter conviction. So really everything the defense is doing is trying to steer away from murder and point the jurors in the direction of a manslaughter conviction.
But one of the things I must ask along those lines is, to me, the defense hasn't clearly said she did it and she thought it was an animal and didn't realize, or she accidentally ran into someone because it wasn't well marked and then she panicked and she fled, And so maybe we'll see that, but do you think it's necessary for a defense to really put one of those theories out there or not?
I think so, actually. The last thing you want to do is alienate this jury by insulting their intelligence and saying, this wasn't me, or not accept some kind of responsibility. You really want a compromise verdict if you're here. I mean, here's someone who was killed tragically, a victim, a law enforcement victim. So you know the jurors are going to want to return some sort of guilty verdict here, and to sort of swing for the fences and try to abdicate any responsibility whatsoever, I think is a poor defense strategy if that's the direction they go in here.
And I don't know yet what they will do, but it was interesting because there was testimony earlier in the case in which they said she's a bad driver, she being the defendant, that she's not even a good driver. That came from the daughter-in-law. And I think all those are facts that the jury is going to take into account.
I think so. I mean, ultimately, DUI is the most common crime in this country. I mean, there may be jurors on the panel that have a DUI conviction or know someone that does. And to sort of make the leap from driving under the influence or driving while intoxicated to murder is it's a pretty significant leap. So again, we'll see what the defense ends up doing. Sometimes there's this wait and see approach by defense attorneys to see what evidence comes in. But I think ultimately they will have to go with, look, there's someone who's a bad driver who made a serious mistake, is criminally negligent, but again, doesn't have that intent for murder. But we'll see what happens.
And I think there's an argument to be made on the other side of that, that she ran, she didn't stay, she didn't come back, she didn't take responsibility. She was actually on the Tennessee Most Wanted list for a short period of time so that they could find her. And so the reality is, if you hit someone in a circumstance like this and stop to render aid or call the police or say, uh-oh, that's a little bit different, I would suggest, than when you can't even be found and they then identify your car. 29 counts. We know it's a death penalty case, but let's talk about, for viewers who are joining us for this trial, is it a possibility that this jury, Neama, can find him guilty of charges that would result in imprisonment but not the death penalty?
It's certainly possible, some sort of compromise verdict. I think that's unlikely given the number of victims. You're either going to get guilty across the board or you're going to get a hung jury. I think when you have 9 victims, 5 of which are children, it's just impossible to really get a compromise verdict. I mean, I shouldn't say impossible. I got to put my attorney hat on. It's highly unlikely that we're going to get something like that, And as far as timing goes, I got to give credit to Court TV lead anchor Vinnie Politan because this is his theorem. But, for every day of trial, he usually expects 1 hour of deliberation. Now, this is a little bit more of a complicated case. You have 2 home arsons, right? You have the 2016, you have the 2017. You have a vehicle arson there in the middle. So maybe you want to add a little bit of a multiplier. But again, if you start getting past that, you start going into days and weeks, it really spells trouble for the prosecution. So they really need a verdict sometime in the next day or so. Otherwise, they may be looking at a hung jury.
Especially as a prosecutor, how do you make certain that the jury is listening to the details of timelines and evidence and facts without getting swept away by the emotions of everything that they're being told happened to 2 different homes, 2 different families?
Well, actually, the timeline that Joy put up really helps. I mean, those demonstratives are great for a jury. And, while you have that up there, you tell these jurors, and this is what the prosecution did, you appeal to their common sense. Every jury instruction regarding reasonable doubt in every state in the country talks about this. What makes sense, jurors? Don't leave your common sense at the door. Is Stanley Ford the unluckiest person in the world that, there's all this evidence tying him and his alarm and his vehicle and his home and the lights at his house and his residences to the exact timing of this murder? Did the boogeyman do it? Did, Boggs and this sort of false confession? Or really, what makes sense? All the evidence points to one person. And whether you use the puzzle analogy or numbers or letters or arrows or, whatever you use, you really appeal to the jurors' common sense on one hand, and really that raw emotion. We heard from the law enforcement witnesses the last final moments of these victims and how they were gasping for breath and hiding in their bathtub with water, trying to just get out of this fire or do something to survive. And, the multiple attempts to light these homes on fire. I mean, there's so many just really, really, and Brian touched on devastating facts that really bring a tear to your eye, especially when you're dealing with children who died this horrific death. So I think you do both. You appeal to their emotions, but at the same time, their common sense. And I think that's how the prosecution is going to get a guilty verdict.
We know that she did not stop. We know that they did not locate her until a couple of days later when they actually saw her. So found her located, were able to question her. As a result, of course, she didn't have a breathalyzer test. She didn't have a blood test. They have no evidence or proof as to an alcohol level. Do you anticipate that the prosecution is going to call in an expert to be able to say a person of her size, having had this many drinks of this type, would or would not be intoxicated?
Ashley, absolutely. In these DUI trials, you need to call a chemist or a criminalist. I mean, that's what the jurors expect. You're going to talk about blood alcohol content and, her BMI and her weight and, how much each shot, how much alcohol it has in terms of ounces and what the expectation would be, what her blood alcohol content would be when she was driving that vehicle. So that's something that's pretty standard. Every local law enforcement agency has these types of experts, and they've testified hundreds and hundreds of times. I mean, going back to the video, I'm sure the prosecution would have loved to just play an edited video of her just taking shots and drinks, kind of similar to the Bob Durst case, right? But the defense always wants to play the full video. Obviously, in Durst, it was the Jinx admission. Here, it's the bar video. The defense wants to play the full video, and under the rule of completeness, most judges will allow that full video to come in, and that's why we're seeing this.
When I was in law school, one of the big things we learned about was assumption of risk, and what Brian just said, ABC happened, but XYZ. Someone was crossing the street and got hit by the car, but assumption of risk because they were not in the crosswalk where they were supposed to have been walking. But I have to say, as we have gone forward in time, assumption of risk sometimes is out the window, and people still are responsible whether there was a risk by the victim or not. What are your thoughts?
Ashley, I think it may have been a good argument had our defendant here, Hines, not fled the scene and been at large for 2 days. So I think that argument goes out the window. If I were the prosecution and the defense tries to argue that, I'd say, okay, if it's an accident, everyone has been involved in an accident. You stop, you render aid, you call law enforcement. You don't take off, and you're not a fugitive. So again, I understand why, from the defense's perspective, it's one of the only arguments that they can make in a case like this, but I don't think it's a particularly good one, and I don't think the jurors are going to buy it here. Actually, this is very hard for the jurors. I mean, most folks already dislike jury service, and now you're separated from your friends, family, loved ones with 11 strangers plus alternates that you don't know. And not only that, they're watching this 5-hour video without any sound and with some bar patrons who are dancing it should be criminal how bad the dancing is there. So it's just very, very challenging for these jurors when you're dealing with sequestration like this throughout the course of the trial. Really, and frankly, I don't even know if it's necessary in a case like this. I understand it for deliberations, but you're really asking a lot of these jurors to be separated from everyone. I know there's always the concern about media attention and public pressure and those types of things, but it's already a challenging case, and it really makes it difficult for folks to serve on juries more than it already is, in my opinion.
In terms of objections,
it does appear to be a relaxed courtroom. Sometimes it's the judge, and other times it's the attorneys. They choose not to object. But I agree with Brian. Party, at least here in Los Angeles, where I'm from, can mean drugs. So it's certainly not something that you want to hear if you're a defense attorney. And I think this was a good witness, for the prosecution here. I mean, she said that her mother-in-law was a party animal, certainly not helpful testimony for the defense. And then she said she doesn't have a drinking problem, but she drinks every day. I think most jurors would say, well, that's a problem if you're drinking alcohol every single day. So a good witness for the prosecution, and I see why they put her on.
They are watching, they being the jury, and I have to ask you this, because we have watched, just during the time, gentlemen, that we've been on the air together, it's gone from a pretty quiet bar to look how many people have gotten up and are dancing all over the place, and it's a lot more active and busy, and I think there could be an assumption watching this that a lot more drinking, and the defendant is in that bar as well. Neama.
Ashley, this is a party. It's popping. We finally got to the good stuff. Look at this lady in red here. She's raising the roof, trying to get this gentleman to dance with her. So, I mean, this isn't a wine and cheese event here. I mean, this is a full-on party here. And, as far as the two drinks, I mean, I got to say, like Brian, I've handled a lot of these cases. Probably more than half the time, the criminal defendant says they've had two beers. So much so, in California, they colloquially refer to DUI as deuces, which means two. So it's not uncommon for criminal defendants to lie about how much they drink. As far as the designated driver, I think that helps the state. Here's a woman who had the opportunity to make a right decision. That's something that we even teach our children. When you have a decision to make. Do you make the right decision or the wrong one? In this particular case, she could have made the right decision. She had the opportunity to get a ride from her daughter-in-law. Instead, she made the wrong decision, not only when she got behind the wheel of her vehicle, but when she caused an accident, killing someone, she made another wrong decision and fled the scene. So I think that's going to be part of the prosecution's closing theme in this case.